Is now live. Okay.
Hello, everybody. It sounds like we are live. Welcome, welcome, welcome. Welcome to Divorce Lawyers Uncensored by the Alumni Institute, where you always have an attorney who's going to answer your questions that are related to divorce real estate. And I've been a family law attorney for just about 22 years. That's all I do. And I am also a faculty member at the Alumni Institute, where we teach you how to best show up in these real estate transactions so you can actually get the transaction finished, as opposed to getting stuck in the middle or not even getting put onto the what we would call case, but get put onto the listing. So feel free to submit your questions in the Facebook group. Our wonderful Sarah is going to let me know of any questions that are put in that group, and I'll be happy to answer them. And then I also have some questions that have been pre-submitted. So just a note, if you ever want to make sure your question gets answered, go ahead and submit that in advance. So we always post where you can do that in the Facebook group. And that's where we're going to start. So I have a question here from Diane Langston. And I don't know where Diane is from, but hi, Diane, if you're on this morning. All right, so Diane says, I have a client in the midst of a divorce. She holds title to the family home as a married woman as her sole and separate property. The husband she is divorcing is demanding his half of the equity in this property, as well as another she owned prior to the marriage. Does she have to buy him out of these properties? Did he give up any rights to the property when he granted her title as sole and separate property? All right, Diane. So one of the reasons I was trying to figure out where you're from is because it's going to matter whether you are in a community property state or you are in an equitable distribution state. And what that is, for those of you who don't know, when each court is dividing property, they look at the statutes, the laws that have been created by the legislatures in that given state. And so in places like California and some other states, I think that most of the states are actually equitable distribution states. Community property states are the ones where people always say, I'm going to get 50% of everything that we own, because the courts say that each party is entitled to 1/2 of the marital estate. That's what happens in a community property state. It's a 50% calculation, let's say. In an equitable distribution state, it is based on equity. So they're going to the courts look at the situation and they apply certain factors to determine how much property each person's going to get, which property each person's going to get. So that's, to start, one reason I was asking that. The other issue, so whether it's community property or equitable distribution state, there are laws. So even in a community property state, let's say a person owns the property, they came into the marriage with it, or during the marriage, they signed off title to the other party. And so now only one person owns the property, and it would be considered their separate property. The other spouse might still be entitled to a share of the equity. And this is going to depend on the laws in your state. So some states have laws that say that if community property monies, which is going to be all money that was earned during the marriage in a community property state, if community property money was used to pay down a separate property loan, then the community, right, so both spouses, including the one not on title, would be entitled to some share of the equity. And it is a formulaic calculation. They look at a variety of factors based on value of the house at different points in time, how much was owed at different points in time, and they come up with a number. So I can't say for certain, Diane, whether this husband would be entitled to half the equity or what share he would be entitled to, but just know he might be entitled to a share of the property. And that's really a question for a lawyer in your jurisdiction. The other question you had was, does she have to buy him out of these properties? So again, if he's entitled to an equity share and she can't find that money from another source, then she might have to refinance and do it from one of these properties that she owns. And then, didn't he give up any rights to the property when he granted her title as her sole and separate property? So the answer is complicated, and that's our favorite thing to say as lawyers. It depends, because there are rules that say if the title was given to somebody, granted to somebody as their sole and separate property during the marriage, there may have been undue influence. There may have been other factors that led to that happening. And in some cases, the courts can say, you know what, we're going to reverse that. And we're for whatever reason, and there are reasons they can give, we're going to deem that property to still be community property. If the husband can, or the wife can jump that hurdle and the court still says, okay, no, it was a valid, what we call transmutation, that's a legal term. If it was a valid transmutation, then it's her separate property. And then you go back to the issue of, well, but did he still get an equity interest for any pay down during the marriage? I love to talk about this stuff. It is complex, which is fun for us lawyers, but it would be important for her or him, really for him, to get a lawyer on the case and analyze his interest in the house. So I hope that answered your question. If you have a follow-up to that, let me know. Oh my gosh, Sarah just told me that we have some of our spring students on live with us. Hello, you guys. We're so excited about the spring Master Course CDRE program that's going to be starting at the end of April, and really glad to have you. I will see you there, and I'm excited to meet each of you. So, all right. Next question is, let's say I have a friend who is getting divorced and she reaches out to me to help sell the marital home. Does this already disqualify me from being neutral from the opposing attorney's point of view? The quick answer is likely yes. I mean, if you're a friend, then you're going to have to really help that attorney see why it is in the other party's best interest to have you as the realtor. And you're going to have to really show them what your strategy is for staying neutral. Because, you know, it's really easy for you to just pick up that normal text thread that you have with your friend and say, oh, hey, I've got a showing coming up. I'm going to be at the house at 4. Well, but that's not really the way that it should be happening, because then the husband or the other party, I shouldn't assume which one it is, the other party is excluded from everything. So you want to make sure that you help the attorney know what your strategy is and how you are going to handle communications in a neutral way, how you're going to handle negotiations between the parties in a neutral way, how you're going to structure your divorce listing and all of the steps that go into the sale of a house, how you're going to do that in a neutral way, and how you're going to ensure that the other party is included at every step of the transaction. And if you can do that, then there are times where you're going to be able to get appointed to that case or be selected by both parties. But it is something that you need to be very diligent about and focus on for sure. So I hope you get it. All right. If one spouse moves out of the house before or during the divorce, does this impact their rights to the property? Would the judge give preference to the in-spouse? All right, so there's 2 parts to that question and kind of 2 different answers. So generally speaking, and you really need to check this out in your state. So this is a good question. If you've got an attorney that you've been wanting to talk to and meet, this is a good question to pick up the phone and say, hey, I've got a quick question about the impact of a spouse's rights to property if they move out of the house. Lawyers love to talk. We love talking. And we love in helping people understand things. So pick up that phone, ask the attorney in your jurisdiction. But the quick question or the quick answer is generally it should not impact their overall property right. So, right, if you're in a community property state, you're still entitled to your share of the house. And just like in Diane's question, the husband would still be entitled to his share of the house if he moves out. There might be some jurisdictions where there is this idea of abandonment. And I don't know what states those are. I don't even know if that's like a real legal theory. I know a lot of people are worried about this idea of abandonment, which is why they need to check it out with a lawyer in their jurisdiction. I know out here on the West Coast, we don't have that idea of abandonment. So if you move out of the house, you're still going to get your share of the property. However, when the court is looking at preference to who's going to get to stay there and buy the other one out, let's say both parties want to do a buyout, which one is the court going to look at? There's a number of factors. Oftentimes the courts are just going to say, let's let them bid. Whichever party is going to pay the most is going to be the one that gets to do the buyout. Sometimes they're going to look at, well, we've got the parent who has the kids, is living in the property. We don't want to move the kids. If they're willing to pay fair market value, then we would let them do the buyout. Usually, though, it often comes down to who's able to qualify. And I just had a case this week where the in-spouse wants to do the buyout, and he's unrealistic about the amount of money that he's going to have to pay to my client. And so one of the things I made sure that we structured into what's going to happen between now and the next hearing is he has to go out and get a pre-approval letter for the maximum amount of money that he can qualify for. And that way, when we're having our negotiations, we can all be in reality about whether he's even able to do a buyout. Hope that answered your question. Hi, Anthony Muscatello. Good to see you. Thanks for saying hi in the chat. All right, next question. Let's see. If there is a restraining order, how does it work when we go to the closing table? All right, this is one of those questions that, again, is going to depend on your different states. So there are some states where they will just meet with escrow, let's say, and you can have one party come in and then the other party come in. There are other states where, I bought a house in Michigan and they just sent me the documents and I took it to a notary and I signed it and sent it back. There are other states where you have an attorney who does the closing, and generally speaking, they're all going to go to the closing table. So you need to talk with the attorney on that case, and I'm talking about the real estate attorney, and explain to them, hey, there's a restraining order in this situation, and how would you like to handle that? You are not going to have them both there at the closing table. Short answer. It's really important. It's a restraining order. You are not in a courtroom. There is no exception in the restraining order for what to do if you're at the closing table. So no, you cannot have them both sitting at the table together. If the attorneys, if their family law attorneys are wanting to have them together for some reason, then it really needs to be structured in a very careful way, because the person who is the restrained party could be arrested. Let's say they go to the closing table and they say something to the other party that the other person doesn't like. They can call the police and this guy's arrested or this gal's arrested, and now they're in a lot of trouble. So you don't want to put your clients in that situation. You want to make sure that you speak with all of your partners, right? So all the people that you work with within the transaction, they need to be aware. So if you have somebody else who's doing the showings, they need to be aware. Hey, there's a restrained person. If they come to the house, you need to let me know or let the attorneys know. If they're, you need to let's say staging is there. I don't know. Anybody who might come across the restrained party needs to know that there is a restraining order in place. And you need to be very deliberate about how you structure the communications. You don't want to put the restrained party in a situation where they are on a thread, like a text thread or an email thread with the other party, and they send a message intending it to go to you, and it accidentally gets sent to reply all. And now they have sent a communication to the protected party, and they could be in violation or would be in violation of the restraining order. So you have to be very careful when there's a restrained party on the case, but you can do it. Laurel does it all the time, where you have somebody who's restrained and you can make sure that they are communicated with effectively, that they receive all of the information, that they're able to participate in the listing if they are your client, and that they are able to sign everything. It's not impossible. Okay. All right. What is the best way to approach a family law attorney to begin a business relationship? You know, it's very interesting. I get this question almost every time. Everybody wants to know how to approach an attorney so that we can refer you business. And my answer always comes back to, you need to be a resource to us. You need to demonstrate how you are different and the way that your listing process is different than the average realtor. So I can tell you, how to call me, right? There's a phone number in the phone book. It's easy. Phone book. There's a phone number online. It's easy for you to call me. But the issue is going to be then, do you know what to say or what to talk about with me once you get me on the line? And that is going to be, like I said, about, you're not asking for a sale. This is a relationship that you're developing, and you need to prove to me that you are different than the rest. And I'm going to tell you that part of the conversation is not about how many listings you've sold, how many awards you've won, how many letters you have after your name, unless they're CDRE. Like, I need to know the education that you have. I need to know that you've dealt with these divorce people, or that you've been trained on how to deal with the divorce people and the nuances of that. Because a divorce case, even on a regular divorce case, it can go from, really amicable, everybody's getting along great, to high conflict. We're in court all the time. Emergency orders are being filed. And I mean, that can happen in the course of a week. I mean, it can happen very quickly. And I want to know that the agent that's on the case is going to be able to handle both of these parties in the event that there is conflict, and that conflict is not going to interfere with getting this house sold. So do you know how to negotiate between both of the parties? Do you know your specific divorce listing process that is going to explain to me how you are going to ensure that the parties are both communicated with, and at the same time that your neutrality is front and center? Also, too, how are you going to keep this listing moving along? When are you going to contact me? And when are you going to not contact me? Like, what is it that you are able to do so that I don't have to be in this transaction and I don't have to be on the email thread between you and the parties all the time? Because that costs my client money. If I'm reading every email that you're sending, that is costing my client money. And I want to know that I can trust you with that transaction, and that I don't have to be on that email thread all the time. But at the same time, that you're going to contact me when it's important. And so, of course, this is always my place where I can plug. We have boot camp, which is an awesome program for people who don't necessarily want to become an expert in divorce listings, but you want to know how to do them, and that you want to understand the differences between a regular listing and a divorce listing. And you want to understand how best practice for getting through that listing. So that is our boot camp. And I'm sure Sarah will post a link for you in the Facebook group for boot camp. And then, of course, for anybody else who wants to become actually a certified divorce real estate expert, I don't know. I have a feeling we may have closed registration for spring, but maybe not. Check in the Facebook group. Sarah will let you know. But that is where we teach people. We really dive deep into how to become a good resource for attorneys. And we also dive really deep into how to serve as an expert, how to testify in court, how to do proper reports, how to handle really high conflict cases. So both are awesome programs. Check them out. And if the registration is closed for spring for the CDRE program. We have another one in August. So check that out. Okay, next question. How do I handle a spouse who wants to list with an agent when the other spouse does not trust or like the agent the spouse is trying to use? How to handle a spouse who wants to list with an agent when the other, okay, I kind of answered that one a little bit earlier, but we can talk again about it. When you have another spouse who wants to use a different agent, then you need to first get an opportunity to speak with the spouse who doesn't want to use you. So the one who doesn't want to use you, you need to have your client, or not your client, take that back. You need to have the spouse who likes you really talk to the other party and say, hey, why don't we do this? Why don't we each meet with the realtors that we are preferring? So I'll meet with the realtor you want, you meet with the realtor I want, and then let's talk about what we want to do after that. And so you can kind of get your foot in the door. And then once you get your foot in the door, again, it's going to be about, they want to know that you are neutral. So yeah, they want to know that you know how to sell a house and you know how to sell it well and you know how to sell it fast. Sometimes one spouse wants to drag it out. So you kind of have to pick up on that. But they want to know that you are going to be their champion as much as you're going to champion the other side. And so that is all about, this is how I communicate. I'm not going to have any special communications with this person that I won't have with you. You will be brought in on all of the anything that's happening in the listing. I'm going to talk with you too about all offers that are made or any recommendations I have. And you're going to be, you are my equal client. And I take that very, very seriously. Okay, so I know her and she found me, and the reason she found me and the reason she's asking me to do this is because she knows that I will be fair with both of you and that I don't take sides, and that my sole purpose here is to get the house sold for the highest and best price for both of you. And you can then talk about your specific divorce listing process and how you do things. And so they can feel confident that they're not going to be left out of the process. And then you can formulate some questions that they can ask the other, say, you know, why don't you ask your preferred realtor and ask them, you know, how do they handle divorce listings? Do they have any experience in that? Do they have any special education? And hopefully you've taken boot camp, and you can say, I've taken a full course on exactly how to be neutral in these cases and exactly how to handle these. Does the other realtor have any experience reading court orders and know what to do with those? I do, again, presuming you've taken the course. And so maybe that's kind of the best answer I have for you. And of course, I am tooting the course here. It's not my intention in these, but of course, it's just a great resource. So if you take boot camp, then you can show up to that appointment with the words, I am specially trained in, or I have special education in how to do real estate sales in a divorce. And that is a special nuanced niche. There are issues that come up in these cases that the average agent is not able or knows how to handle, but I do. And again, focus on the neutrality, and hopefully you can get in with them. All right, let's see here. We have just a few more minutes. All right, here's a sweet one. Given that we're mindful of your time and the client's money, yay, can you give examples of when realtors absolutely need to communicate with family law attorneys about real estate matters? Yeah, so that is, you know, at Alumni, we teach that there are very specific points in time that the attorney definitely needs to be contacted. You've got your, when the listing is signed, when there's a offer on the house or the house goes under contract, well before the house is to close, when the house closes, and then also too when there's an impasse, when you have done your best to handle high conflict in the case and you can't get cooperation from one of the parties, you're going to make sure that you're going to reach out to the attorneys at that point in time. You don't want to have this thing going on and on and on and just getting stale. Days on market are not okay. And even though it's a divorce listing, and a lot of people are going to say, well, it was a divorce listing, and so, you know, I just happened to do that. I couldn't fix it, or I couldn't get cooperation. You have a million excuses. In the attorney's eyes, those are not okay. Days on market is not okay. You need to make sure that this listing is moving and moving, because one of the parties inevitably wants this sale done sooner than later, and the other one might be dragging their feet. And if you cannot get cooperation, then there are legal remedies to get cooperation. And so the attorneys need to be notified. I'm not saying to just blast both attorneys when one of the parties is not cooperating. You might want to reach out to the non-cooperating spouse's attorney if you've been given authority to do so, and talk with them and say, hey, I've got a problem here. And is there anything you can do to help me? I've put up 10 showing appointments and 9 have been canceled. Whatever, but you need to make sure that people are involved so that you can get resolution. But you also want to make sure that we are involved at specific points in time, so that we don't just show up one day and now the house is about to close, escrow is about to fund, and now we realize, oh my gosh, escrow is planning to disperse funds to both parties when we have not finished the divorce yet, and we need that money to be put into a trust account. There's many reasons why you need to be communicating with us along the way, and those ones are kind of the most important, but not the only ones, only times. Okay, I sent a question regarding whether a spouse not entitled to the property who has signed off. Oh, I answered that question for you, Diane. I'm not sure if you just posted that again, but go ahead and watch it on replay, because I answered, that was the first question I answered today. So if you have a follow-up to that, let me know. And I think that's it, you guys. All right, we can go ahead and finish a little bit early unless anybody else has another question. I am happy to answer those. Something happened outside. I wish you all a fantastic week and weekend. Happy St. Patrick's Day. I hope you have something fun planned to celebrate, and we will see you next month on Divorce Lawyers Uncensored. Have a great month.